So the best part of the day is awards and work health and safety. I'm sure that you're all above board on this, you know all this information. So I'll try and touch on it. Don't forget to ask your questions as we move through the presentation. So, applicable sources of information for you. So, the Industrial Relations Act 1999 and the Regulations 2011, the Work Health and Safety Act and Regulations 2011. You should also be aware of the information from your industrial organisation like CMS, and the other bit of information for work health and safety that you should be aware of is the Guide to Preventing and Responding to Workplace Bullying. Now, while it is a piece of federal legislation that comes out of the Fair Work Act for employers in Queensland, this piece of legislation is used with the Department of Health and Safety or WorkSafe Queensland, as you may know it. So they're the people, for example, if we're going to discussing whether you have a case of food poisoning in your tuck shop and you have a, for the work health and safety legislation, we WorkSafe Queensland who would come in and probably do an investigation of your workplace, let alone before we even get to the coroner inquest, okay, if there's a death. So if you don't know of those, you don't have to know those. Do you have to be an expert? No. You talk to somebody like CMS to ask your questions, get up-to-date information. There we go. So you just need to know what legislation applies to you. You just need to know what awards apply to you, where you can access that information. So for awards, you can access them on the CMS website, or you can go to the Queensland Industrial Relations website and look at the awards online. You'll find your awards there also. And obviously, again, once you can talk to CMS, and if you're not with CMS, then whatever industrial organisation you are affiliated with. So today we're going to talk about ordinary hours of work. These are just quickly, I'll run through these. Casual loading allowances, minimum and maximum engagement, sorts of leave that your employees may be having, and termination requirements. Excuse me if I'm talking a little fast, but they've given me 35 minutes to get a lot of information across to you. So P&C Association and the Retail Award, which is the one that you'll use for your retail. So your tuck shop, your book shop, your uniform shop, your hall convener will all come under the Retail Award, okay? And it has a maximum of 8 hours a day, ordinary hours for a casual, and 8.5 ordinary hours a day for a permanent employee, so your full-time and your part-time employees. Children's Services Award, how many of you here run in OSHAs as well? So just a couple. So 8 hours a day is your maximum hours during term time and up to 10 hours during vacation care. But you can't do 10 hours a day during during term time, all right? Casuals have a maximum of 33 hours a week during term time. And they can work full-time hours during vacation care. So if you have a casual in your OSH that's working more than 33 hours a week, then you need to see whether you need to make them permanent part-time. And your coordinator is entitled to some non-contact time, a minimum of 15 hours non-contact for each hour of contact they have supervising children. That would... 15 minutes, did I say 15 hours, did I? Yeah, okay. Sorry, 15 minutes of non-contact for each hour of contact that they have supervising children. Obviously, if they're not supervising children, they're a non-contact coordinator, then they just get paid for the hours of work. They don't get any additional hours of work. So loadings and allowances. So your P&C Award has a 25% casual loading. But your employees who are casual in your OSH only get 23% casual loading. So you need to know that there is a difference. And while I haven't written it up there for superannuation, superannuation is paid quarterly for OSH employees and must be paid monthly for your retail employees because there are different award requirements. So you can choose to make your children's services employees, you can pay them quarterly their super and monthly for your retail employees, or you may choose to pay all your employees monthly, so it's one process that you do. First aid allowance is only paid to the convener or somebody in the tuck shop if they are required to be the first aid attendant. Just because they hold a qualification doesn't mean they're entitled to the first aid allowance. Many tuck shops or P&Cs, because the tuck shop may be in close proximity to the school office, they may use the first aid officers in the school as their first aid attendant for the canteen. Okay, and in your outside school hours care, only unqualified employees are entitled to the first aid allowance, because when they did the equal remuneration case in 2006 with the Children's Services Award, they included in the hourly rate for employees with qualifications of a Cert 3 and above an amount of money to compensate them for maintaining their first aid qualifications. So there's no requirement to pay the first aid allowance to any employee other than those who are unqualified in the outside school hours care. Okay? I beg your pardon? No, yeah, if you're requiring them to offer first aid. So all of those who have a Cert 3 and above in the OSH would be required to offer first aid assistance, because they get those qualifications as part of getting a Cert 3 or a diploma. They do the first aid as part one of the units of the training. So they're all required to do first aid. Now, if you want your unqualified staff to offer first aid, then it's your requirement to, one, train them, and secondly, pay them the first aid allowance, because they're not compensated in their hourly rate for obtaining and maintaining the first aid qualification. Okay, in the tuck shop there's no broken shift. That means you can't, say, do 2 hours in the morning and come back and do an hour in the afternoon and just get paid to 3 hours. If you come to work twice a day, you get 2 3-hour minimum engagements. Or if you're permanent, it could be counted as overtime if you've already done your 3 hours, and you would just be paid for the additional hours of work you do on the second engagement. Yes?
For a casual, is it minimum 3 hours?
Yes.
So if we only need them for an hour, we have to pay them?
You have to pay them 3 hours. And that minimum engagement in the children's services in the OSH is 2 hours. So this is the difficulty with being volunteer employees, is understanding that not all awards have the same parameters around what conditions employees have. So that's why we would hope you would phone us. Yes, Michelle?
Susan, just on that 3 hours, because I know that's an issue we've had quite frequently, you can actually have them do other work during that 3 hours. So you can say, all right, you do an hour and you pull shop, and then the other 2 is helping out the tuck shop.
That's exactly right. So if it's your... So if they, because they're the same award, and you only need a uniform shop convener for an hour, you can put them to work in the tuck shop for 2 hours. All right? So there's no problem with that. But what you can't do is give them an hour in the morning and an hour in the afternoon, or an hour in the morning, 2 hours in the afternoon, because that's actually 6 hours that you need to pay them. Okay? And there's no crib break. But there is a broken shift for the children's services, and though it doesn't apply to casual employees in the OSH. It only applies to permanent employees. So if they're a permanent employee, the 2 hour minimum engagement can be split an hour in the morning and an hour in the afternoon, and you pay them the broken shift allowance. But casual employees, they would get a 2 hour minimum engagement in the morning and a 2 hour minimum engagement in the afternoon. There's no broken shift or crib break. A crib break means where you're paid to work through your meal break. There's no such animal in tuck shops. So tuck shop conveners working in excess of 5 hours must have a meal break, a 30-minute meal break by the end of the 6th hour. You can have it anywhere between the 3rd and the 6th hour, but it must be completed by the end of the 6th hour. Or if you choose to work 6 hours straight, you can do 6 hours straight without a meal break other than your 10-minute rest pause. But the moment you go over 6 hours, then it's overtime until such time as you have a break or you finish work. So, and it's no choice. Your roster should include a 30-minute unpaid meal break. Yes. The meal break is unpaid, and it's up to your employer, so the P&Cs, to ensure that you have the opportunity, if you're a convener, to have your meal break. Right? And whether that is making sure there's some volunteers to come in and replace you, or whether you pull the shutters down for 30 minutes so staff can't come in and interrupt your break. You've got to have an uninterrupted break of 30 minutes. Or you can work 6 hours and leave work at the end of 6 hours. And you can't, sometimes it means that you can't all sit down and have your lunch together. You may need to stagger your lunch breaks. So if you've got a tuck shop convener and 2 or 3 tuck shop assistants, it may be that you need to stagger your meal breaks so that there is work continuing to go on and that there is somebody perhaps to give counter service. And crib breaks in the OSHA you only use primarily during vacation care. They should never be used during term time because you're only there for short periods of time. But in vacation care, you're working long days, you may be on excursions where it's hard to relieve somebody for an unpaid meal break. So therefore they have what they's called a paid crib break. And that's the only time you should be using a paid crib break in outside school hours care. So all permanent employees, those employees who are paid the permanent wage, are entitled to 4 weeks annual leave a year. In the tuck shop employees, they get 4 weeks annual leave, regardless of whether they work 52 weeks or not. If they work the 40 term weeks, they get 4 weeks annual leave at the end of the year. So for example, if they work 25 hours a week, they get 4 weeks annual leave at 25 hours a week, so they're getting 100 hours of annual leave, plus they're getting 17.5% annual leave loading. Whereas, because it's a term time award, the award specifies that you're basically only employed for term time. However, in the outside school hours care, the award is not term time, they're employed for 52 weeks a year and their annual leave is accrued through the year, and they can take their annual leave any time that they apply for it and it's approved by their employer. Whereas their school retail employees must take their annual leave at the end of school break. And the reason that that's specified in the award is to make sure there's not a period of greater than 2 weeks in the year when the employees don't have any income. So they don't get paid for Easter, June, September, October school holidays, and they have a 6-week break of which we're made up of 4 weeks annual leave and up to 3 public holidays during that time. And then obviously whatever period it is before you get paid when you come back to work, so it's a week or fortnight. If an employee comes in and requests to have leave other than at Christmas time, it's really important as employers that you counsel your employees about, do they know the consequences? If you take leave at this time, do you understand you'll have a much greater length of time without any income at Christmas time? And if they understand that, then you just get them to put their application in writing and you approve it in writing. You need to cover your back and you need to have evidence that they actually made that request. Because what you don't want is them coming back at some time and said, I was forced to take that leave or I didn't request it. Okay? And that comes to the point that leave must be made on application. They must put in an application, and if you don't have an application process for annual leave, I'd certainly recommend that you implement one now so that you've got evidence that they've requested the leave and that you've approved it. And then obviously there can be a part on that form where they can apply to cancel leave. So important to talk to staff about, don't go and book the cruise and then come and ask to take long service leave or annual leave, because it might not be appropriate time for them to take leave. So sick leave and carers leave. Here in Queensland, carers leave comes out of your sick leave. So it's a total of 10 days a year. They can use up to 10 days a year as carers leave. So carers leave is for caring for someone in their immediate family or household who is obviously needs their attention. And they can be required to provide evidence. So doctors will often provide a carer certificate, you know, to say they're looking after a child with a broken leg or somebody whose husband who's had an operation or something like that. But it's a maximum of 10 days here in Queensland, and if they want to take more than that, then they need to apply to the P&C, and the P&C can say yay or nay. You're not obligated to give them more than 10 days carers leave a year, and that comes out of their sick leave. So obviously if they don't have enough sick leave to cover 10 days, then obviously they can't have 10 days carers leave. And again, their sick leave for the retail employees is they could take leave without pay, minding that leave without pay doesn't break the continuity of their service, but it doesn't count as service, so they're not accruing leave while they're on unpaid leave. So it will lessen the amount of leave that they'll have at Christmas time. Okay. Long service leave. Every employee here in Queensland is entitled to 13 weeks of long service leave after 15 years. At the end of 10 years, they can start taking their leave while they're in your employment. So after 10 years, they will have accrued 8.6667 weeks of long service leave, which they can make application to start taking. And we would recommend that you do not let them just have an ongoing accrual. It is not an additional bank of money that they can access when they retire. For example, I'm dealing with a P&C at the moment who has a long-term employee that when she first started accruing her long service leave was getting paid $9 something an hour. So now, some 20 odd years later, it's now nearly double that. So, well, it's double that. So that long service leave, which hasn't been taken, is now doubled in value to the P&C. It's a financial impost to P&Cs to allow an ongoing accrual of long service leave. So, pardon? Yes, leave is always paid at the wage that they're on at the time of taking the leave. So it's important that you say to your employee, we note that you've got a lot, so whether it be long service leave or annual leave, for your OSH employees, you need to say to them, we note that you have a large accrual of leave. Can you please provide to us a timetable where in the next 12 months you will take and stipulate how much you would like them to take, a timetable. Now, if you can't agree on the scheduling of when that leave will be taken, with long service leave, you can give your employee 3 months' notice in writing of when they must take at least 4 weeks, but you can stipulate a bigger chunk to be taken. Or for annual leave, it's 14 days' notice of when they need to take some annual leave. Yes? No, they're not. You cannot cash in your annual leave or your long service leave. If you have some financial difficulty, you can make application to the Industrial Relations Commission to take a monetary amount, but you actually need for them to approve it. Okay, you need to usually prove financial hardship. I've only ever had one cashing in of long service for financial hardship, and it was during a drought many years ago, and they actually looked at their bank accounts and they even queried where they'd got a $2,000 deposit from. They'd sold some farm equipment to cash in. They're very strict about giving long service leave on financial hardship. You do need to prove it. It's not just a case of filling in the paperwork and lodging it with Commission.
So the request you put in, if it does accrue, should you wait after the 15 years or after the 10 years?
After the 10 years, you can start asking them to take it, and don't just tell them you've got to take it and you've got to take it now. The first one would be to request them to provide to you a schedule of when they may take their long service leave. So if they're planning a trip in a year or so, then that's fine. They're going to take it in the sort of near future, and that would be fine. But if they say, oh no, I'm going to keep it until I retire, you'll say, no way, Jose, you need to provide us a timetable when you're going to start taking it, because it's money that could be in the bank ready for kids to be, spent on kids instead of for their pocket. Bereavement leave, all employees are entitled to bereavement leave. Your permanent employees get 2 days on each occasion. It doesn't come out of any other sort of leave. Okay, it's just an entitlement. So if they unfortunately have half a dozen deaths of their immediate family or household, then they're entitled 2 days up, including the day of the funeral, for bereavement leave. Casual employees don't have paid bereavement leave, but they can have unpaid leave, which means basically that they don't lose their place in the roster because they've taken some time off for bereavement purposes. So termination of an employee. Here in Queensland, you are required to give up to 5 weeks' notice of termination depending on the length of service. The 5th week comes for employees who've been in your employment for more than 2 years and are over the age of 45. So that after 5 years, they get 4 weeks, but if they've been there for that length of time and they're over 45, then you're required to give them an additional week. In reverse, the employees are not required to give that additional week, so the maximum they would be required to give is 4 weeks. However, in the outside school hours care, the notice by an employee is only 1 week. They don't have to give the same notice as the employer. So, any questions, before I move on to work health and safety, any questions on the award? Yes? Oh, the pro rata long service leave. After 7 years, they can be on termination. That means either resignation or you terminate them. They may be eligible for pro rata long service leave. There are very strict criteria. one, it's paid on death, obviously, into their estate. If they provide evidence that they're too sick to continue in their current role, that the position is made redundant, you would pay it, or if there's pressing and family necessity, there's a reason they've left work. So pressing and family necessity could be that the spouse or partner has moved location for their job and obviously makes it impossible to continue working for you because they're travelling with their partner to a new location. It could mean that they've had to retire to look after disabled children or elderly parents. That would be family necessity. Okay? Yes?
So you had a casual that started on, say, 11 hours a week,
Yes.
and then she moved up to 14 hours a week. Like, when you pro-rata long service leave, there's obviously some sort of calculation, is there?
Yeah, total number of hours worked, so like 12,000 hours. If we're talking canteen, you would divide it by 40 or 41 weeks. If it's OSH, it would be divided by 52 weeks, multiplied by 0.86667. That will tell you how many hours, and then multiplied by the rate at which they're currently being paid. So that's a quick way to calculate it. So work health and safety.
Just one quick one, with that long service leave, must they start taking it after 10 years? Or is it optional to take it after 10?
It's when they can start taking it. What I'm saying to you, the longer you leave it for them to start taking, the more money it costs you as an employer.
But at what point must they start taking long service?
I would think that you have P&C decides what their policy is. I know kindies who have a policy that says within 6 months of it becoming available, they need to provide a schedule of when within 12 months they'll start taking it. So you need as a P&C to decide what is your policy about taking long service leave, and let your staff know. Once you've approved that policy, let your staff know what the long service leave policy is. Document it and make sure that they're informed and sign off that they understand. Provide them with the leave application forms to take that leave. The other part of your job as an employer is work health and safety. Ensuring that your employees and your visitors and your volunteers and even your P&C members are safe in the workplace. As I mentioned before, that's the Work Health and Safety Act and Regulations 2011. So you have a primary duty of care. So Section 19 talks about your primary duty of care, and Section 27 talks about duty of the employer or the officers, that's you, the P&C members. So what are your responsibilities about making the work safe place? And then Section 28 is the duties of workers. So funny enough, workers must make sure they don't do anything to put themselves at risk or anybody in the workplace. So the people who work with them, visitors, clients, anybody else who comes into work, contractors, they must ensure that the workplace is safe, and they do everything that they can to make the workplace safe. And obviously there's a general duty of care to anybody in the workplace to make sure that they are well cared for. So there's talking about vicarious liability. Is the employer responsible for what happens in the workplace? Yes. Just because you're not there doesn't mean that you're not responsible. So you need to make sure, as well as the persons, so this is talking more about harassment as well. So when I talk about health and safety, I'm talking about harassment, and I talked about the prevention of and responding to workplace bullying. So that's your responsibility. You can't turn a blind eye to it. You must ensure that everybody is safe, and that's emotionally as well as physically safe. And obviously includes sexual harassment. So you are responsible even if you're not in the workplace. So how do you do that?
Excuse me. I just wanted to clarify as well that the duty of officers, that's the executive of the business.
That's executive, the runners of the business.
It's actually the executive.
Yeah, the people who run and operate the business. Okay? So a defence for your liability is not that you didn't know. You must make all reasonable steps to make sure that the place is safe.
Can that come from teaching staff or principals, or someone that's actually employed by the Department of Education?
What comes from them?
Like bullying tactics?
Yeah, bullying can come from anybody. Bullying can come from people you work with, it can come from visitors into the workplace, it can come from your volunteers, it can come from the teaching staff at the school, it can come from the principal, it can come from anybody. You know, whether it's a case of, we'll talk about it down here. So you can't avoid, we'll just go past, you can't avoid your legal responsibilities for saying they were not aware of sexual harassment in the workplace, and that means other sorts of harassment as well. So when is an employee subjected to behaviour other than sexual harassment? So it needs to be repeated to be harassment. A one-off event is not harassment. Somebody may just lose their temper or speak inappropriately once, right? That's not harassment. But if it was repeated by the same person or repeated by a number of people, then it becomes harassment. A one-off event, how inappropriate, doesn't make harassment. We all do things sometimes that are inappropriate and we're sorry for it. As long as we apologise and don't do it again, then it's not harassment. So the person considers to be offensive, intimidating, humiliating or threatening. So it can be somebody invading your personal space, touching you inappropriately, wagging their finger while they're raising their voice, humiliating you in front of other people. Okay? They can all be offensive or humiliating. But you need to contextualise what is offensive. I mean, I once, many years ago, went to TAFE and did a course, and I had a large number of Korean students in my class. Their personal space is not the same as ours. They will stand here because that's what their normal personal space is in their community. And I would find myself taking one step back to give it what I would consider acceptable personal space, and they would be taking one step forward to what was making their personal space. It was about having a conversation that you were feeling uncomfortable with them being so close, and could they step a little further away. So sometimes it's about contextualising and understanding, not just assuming people are doing it to make you feel uncomfortable. Sometimes there's a reason they're doing it, and you may need to have a conversation with people. Let them know that what they're doing first up is inappropriate, or you're feeling uncomfortable about it. A reasonable person would consider it to be offensive, humiliating, intimidating, threatening. Okay, so these are some more examples. Abusing a person loudly, usually with others present. Okay? Repeated threats of dismissal. Do as I tell you or you're going to get the sack. And if you repeat that consistently, that's bullying and harassment. Okay? You can't do it. If you've got a problem with somebody's employment, you take them privately, you have a conversation, talk through the issues and try and resolve the matter. Don't just threaten them, because it's no use threatening somebody if they don't know what the problem is. They may very well know what the problem is and they're yanking your chain, but the point is you as the employer needs to approach it in a professional manner, and if you can't do it, then sort of ring CMS and we can have that conversation for you. You know, we don't have that personal investment in your employees. And it's not that we don't have any empathy for your employees, but we haven't got any emotional attachment to the process and can just talk about it as it should be spoken about. Constant ridicule and put down. If you've got concerns about the way somebody behaves, again, a personal conversation privately to them. So whether it's their bad taste jokes or whether it's that their personal body odour is offensive, don't make fun of them in front of other people about stinky poo or whatever. Pull them inside and... I know it's a difficult conversation to have with people, but you sometimes need to say to somebody, look, do you understand in this close environment, and it's a hot day, that your body odour is quite offensive, right? Yeah. Yes, I know, it's not a good conversation to have, but you do have to have it because you've got to make it comfortable for everybody in the workplace. And it may be that they have a quiet word to you that things are a bit tough, and really deodorant has not been one thing that they've been able to afford. You know, and you may be able to come to a solution. You know, we don't know what's going on in people's home lives. We don't know what their stresses are. And having that quiet conversation allows them to say, look, yeah, I understand, but I can't afford this at this time, and you'll be able to find a solution for the problem. And I'm sure if you went to your P&C executive, they probably wouldn't mind buying a can of deodorant out of your petty cash on that occasion. I don't know whether Michelle would say it's a legitimate expense. But there is a solution to the problem. Unless you just leave it in the thing and anybody can use it. Leaving offensive messages on email, telephone, and can I add to that Facebook and Twitter and all of those other social media. Just because you posted outside work time doesn't mean that it doesn't count as bullying and harassment in the workplace. You know, because if they're reading that at some time, if you're sending it, say, on an email account that is in the P&C name, and they're going, even though you send it at 1 o'clock in the morning, but they might read it while they're working, say it's to your tuck shop convener, from a tuck shop assistant or volunteer, then it can be harassment and bullying. Again, if you've got a concern, follow your grievance process within the workplace. Who do you go to if you've got a concern? It may be you raise it with the person you've got a concern with. It may be your colleague, your other tuck shop assistant. You might then raise it with the tuck shop convener. If that's not resolved then you take it to the ops manager if you've got one. If you haven't got an ops manager, then it will be the line manager from the P&C. But you should always try and resolve it at the lower level first up. And it becomes difficult if people can't put their personal relationships aside. So we have cases where the tuck shop convener may be friends with the tuck shop assistant and it's not going to deal with it because they're friends. So then you need to go to the next step, and if you're the line manager, then you're going to have to deal with it, and you're going to have to direct your tuck shop convener to ensure that that bullying doesn't occur in the workplace. And not only if that doesn't occur, then you're not only going to be dealing with the tuck shop assistant who's bullying, you may be dealing with the tuck shop convener who's not doing her role as a supervisor and ensuring it's a safe workplace for all people in the workplace. And the other thing is sabotaging people's work. For example, deliberately withholding information so they can't do their job properly. Don't pass on training. Not supplying the correct information, hiding documents, just so that they falter and make sure that they can't do their job properly. I've even seen this happen from executive, not giving the right information to their staff, white-anting their performance so that they've got an excuse to ring me and say, hey, I need to get rid of this somebody. And then when I look a little bit harder, they've not done the training, they've not passed on the information, and the employees as being left to fault it. So you need to make sure that you don't do any of those things, because we would investigate. We would say to you, well, what training? Where are your policies and procedure? When was the last time you talked to your staff about this information? And, you know, when did they sign off that they understood it? Other examples, maliciously excluding or isolating. Just ignoring somebody at work, not saying hello or goodbye. It's all right, you don't have to like who you work with, but you have to find a way to work with them. So you need to have that please and thank you, hello, goodbye. You don't have to have any conversation about your social or your family or any of those things, but you need to have some general manners and interaction in the workplace. You can't tell everybody else about a work function but not tell somebody else. Exclude them. That's bullying and harassment. We talked about criticism, humiliating through gestures or sarcasm. How often do I hear about they rolled their eyes at me, you know? Or, you know, they go, you know, and it's not that they're actually saying something, it's just that they're doing things that you know that everybody else would interpret as inappropriate or a criticism of what they've said or done. And spreading gossip which is false and malicious about somebody. You shouldn't gossip. And in your canteens are not for gossip. You don't talk about teachers. You don't talk about I hear somebody laughing there. You don't criticise your teachers. You don't criticise your principal or your deputy principal or other parents or children in the school. If you've got a problem with children, if you've got a problem with teaching staff, or the principal or the deputy principal, you take it up to the school office and have the conversation there, okay? And if you're the convener in a canteen, if they start gossiping, you shut it right down and say, no, let's change the subject, that's not an appropriate conversation. And if the convener is leading the conversation, you're a big strife because you're not representing the school in a good way. Because not only do you represent yourself, but you represent the P&C and the school when you're in the canteen. And a lot of the complaints that we hear about is the yelling and screaming that comes from canteens, the abusing of staff members to volunteers, of volunteers to staff members, and off to children. You'd be surprised how many times we hear about conveners and assistants swearing and being rude to children, being not empathetic to their need that they haven't got lunch today. What do you hear again? I'm not giving you lunch, you get up the office. That child, you don't know what sort of home life that child comes from, what's caused them not to have lunch today or yesterday or the day before. You've got to show some empathy. You know, it's not your place to judge. Your place is to be empathetic, to be polite, and to provide them. So if the policy is that they need to go to the office, first, before you provide them with a free meal, you say, you know, why don't you go up and see the deputy principal? They'll give you a chip. Come down and then I can give you a lunch. Whatever your policy is in your school, then you need to be empathetic to them, and you don't judge them because you know their parents are bad parents. You may know they're bad parents, but don't take it out on the kids. So for employers, what do? Have accessible policies on discrimination and sexual harassment. Educate your staff about policies and acceptable behaviour. So once a year, have an induction day. So one of those pupil-free days at the start before school starts. While one of them may be preparing your canteen for bulk orders and cleaning and getting ready and turning the freezers and everything back on, one of those could be an induction day where you go over the policies and procedures, may even bring some of your volunteers in to go through procedures as well, and so that you all get set up for the year on the same foot. Display posters and materials and promote anti-discrimination messages. Have clear procedures for dealing with complaints. And I talked about a complaints process before. Make sure you have one. If you haven't got one, then let the P&C, as employees, help the P&C develop a complaints procedure and make sure everybody's aware of it. Having clear procedures, appointing and educating contact officers. So if you're in a large employer, so some of our schools have, 20 or 30 employees, you might want to appoint somebody as a contact officer for dealing with complaints, whether it be sexual harassment or all complaints in general, and periodically review policies and other measures. So don't just do your policies and forget about them. Review them on a regular basis and have input from your staff into those reviews, because they're the ones who are working to them and they may find there's some inadequacies and some improvements that they can offer. So here's a checklist for harassment-free workplace. It's in the back of your presentation, so you can use that, which is just as a bit of a tick box for the things that we've just been talking about. And if you have any further questions, then you can contact CMS. So, I knew I'd had to talk quickly to get it through. So I'm just asking if I've got any questions, Kath. Thank you.